Okay, so what's happening in the world of law that's relevant to you guys? There was a recent case in the Supreme Court which was talking about the builder's responsibility to come back and repair defects, or conversely, the right of an owner to refuse the builder the opportunity to come back and repair defects. So you'll probably all be aware that the Home Building Act says, Section 48MA, that the preferred outcome of an application, whether it's in the tribunal or in a court, is that the builder have the opportunity to go back and repair defects when an owner makes an application about defective work. So that's a legislative imprimatur, and it reflects the common law a little bit, because with the common law in terms of damages, the plaintiff, the applicant, has an obligation to what we call mitigate their loss. So in other words, you can't say, okay, well, you've caused me loss, so I'm going to go and find the most expensive person I can to come and repair that loss. You've got an obligation to be reasonable in reducing the amount of damages that is incurred and the amount of cost. And often that will involve allowing a defaulting builder to come back and rectify. But do you have to? And I'm sure that a lot of you who work in that in the expert advisory part of consultancy will find that clients are expecting that they'll never have to see the face of the builder again. That presumably, if they get to that point, the relationship isn't great, and so they never want him or her darkening their door. But the fact is, you've got to give them an opportunity. So when can you refuse? Well, this is what this case was about. So what had happened here, not untypically, the owners, it was an owners corporation in this case, same applies to an individual. Complaint to the department about defective work, a rectification order was made. The builder did some of the work under the rectification order, didn't do all of the work under the rectification order. The owners corporation had a bit more correspondence with the builder, couldn't really get anywhere, so they commenced proceedings just inside the 2-year, because it was a maintenance issue largely, 2-year, some of them were maintenance issues, 2-year limitation period, and told the builder, don't bother coming back, we're going to do it ourselves, excluded the builder from rectifying the outstanding defects. Subsequently, so after the proceedings had commenced and they probably got some advice from a lawyer, they said that they would allow the builder back on site provided the scope of works could be agreed. There was a bit of argy-bargy, and there was never an agreed scope of works that ended up being the subject of allowing the builder to come back, so they didn't. So the builder claimed in the proceedings that they had been unreasonably refused access, and therefore the owners corporation wasn't able to claim the amount of damages, which was effectively the cost of rectification by a third party, that they were claiming. So what did the court say? The court said, well, look, the relevant principles are these. The plaintiff's not entitled to recover losses that are attributable to its own unreasonable conduct, which might be refusing the builder to come back. In building contracts, that means you've got to give the builder the opportunity, except where the refusal is reasonable, or where the builder has repudiated the contract by refusing to conduct any repairs. Now, if the question of, and of course what's reasonable depends on the circumstances of the case, and one factor is what attempts the builder has already made to repair the defects, and whether the owner or owners corporation has reasonably lost confidence in the willingness and ability, those two things, of the builder to do the work. Now, if the owners corporation or the owner says no, you can't come back, it's for the builder to prove that that's unreasonable. It's not for the owner to prove that they've acted reasonably. The onus is on the builder to prove that the owner has acted unreasonably. And you look at the whole of the history of the relationship. So what was the story here? Well, the court said They thought that the Owners Corporation had reasonably lost confidence in the willingness and ability of the builder, mainly because the builder and the builder's representative had failed to respond properly to the scope of work when they'd been asked for a scope of work and to agree to it. They'd failed to respond to that properly. The poor quality of the work, and even when they'd come back and rectified some of the work, even that rectification wasn't to a proper standard. And this was an owners corporation, remember, so block of units. As those of you who dealt with owners corporations, sometimes it's very difficult because you've got all these different lot owners. You've got to make appointments with them all to come and inspect the units. Appointments have been made and the builder hadn't bothered to turn up to half of them and had tried to change them at the last minute. And when the builder hadn't made the appointed time, the builder would just turn up of his own volition and go knocking on doors. And so that was another factor which indicated that it was reasonable for the Owners Corporation to have lost this confidence in the willingness and the ability of the builder to rectify. So ultimately, the court found the builder hadn't shown that it was unreasonable of the Owners Corporation not to allow the builder back on site, and the builder was required to pay not only the whole of the damages that the Owners Corporation had incurred with the third party, but also the Owners Corporation's cost of the proceedings. So, takeaway from that is, whilst the starting point is you've got to let the builder back, if it's reasonable to refuse, then you don't have to, and it's for the builder. If the builder makes the allegation that it was unreasonable, it's for the builder to prove. So, something you can tell your clients about that. Now, Dale, am I handing straight over to Jason? Are we having
no, let's have breakfast.
Have breakfast?
Yep.
Okay, just before I go, I know you guys like to hear strange things that are happening in the legal world. The place that often strange things happen, of course, is the United States. I don't know about you guys, but I have a pet hate at the moment in terms of fashion. What do you can see? And that's this current fashion of, I'll say the young people, wearing these jeans with holes in them. They actually pay to have holes in their jeans. Now you may remember that I think before this current trend, the trend was for, again, the young people to walk around with their pants halfway down their back sides. And that always used to annoy me and my wife as well. Well, you may be interested. You may be interested to know that in the States, in Georgia, down in the deep south, they actually passed a bill banning pants that sagged more than 3 inches below the crest of the ilium, exposing the buttocks or underwear. They actually legislated it. And the reason they said was that wearing sagging pants is injurious to the health of the wearer, as it causes an improper gait. Well, as it turned out, it wasn't just the gait that was a problem for the health of the wearer, especially if you were in range of a fellow by the name of Kenneth Bonds. So what happened there was that he was arrested and charged with aggravated assault after he shot a 17-year-old low pants wearer in the backside. Reportedly, the victim and a 16-year-old friend were walking near Bond's house. I mean, I don't know whether we've only got Bonds in Australia or in the States as well, but that's a little coincidence as well. But when Bonds began yelling at them to pull your pants up, the boys ignored him, which made him even angrier, and they didn't improve his mood by then calling him a fat ass who needed to shut up. Unfortunately for them, the fat ass had a handgun. And he fired off several shots at the boys as they ran away. It may be that their escape was hampered by the sagging pants, I don't know. But they clearly didn't get away quickly enough because the 17-year-old, one of the bullets intersected with his buttocks. The wound wasn't critical and he was treated and released and was subsequently able to limp back to the police station and identify Bonds from a lineup. It could have been much more serious, I suppose, but you know, the moral is clearly there. If it's bad fashion, it's dangerous to your health.